Next, we're going to hear from Dr. Gali Aviv, who is the head of the Israeli Courts Research Division in the Israeli Supreme Court, and she'll speak to us about the Israeli experience in measuring justice. Thank you, Gali.
Hello. Before I begin, I would like to thank the organizers and Professor Shitrit in particular for inviting me to speak at such an important conference. Today, in the short time I have, I plan to tell you about the Israeli Courts Research Division, research we conduct, and our connection to the European Commission for the Efficiency of Justice, CEPEJ. So the Israeli Courts Research Division was established in December of 2010 as part of a global trend of transitioning to evidence-based policy in a format similar to that of the Federal Judicial Center and other research departments in the criminal justice system in Israel and abroad. The division was established in order to provide empirical data and evidence-based recommendations to the Supreme Court President and the head of the court administration. The data collected is designed to assist in the management of the judiciary and advance the quality and efficiency of the Israeli Supreme Court. Our studies, which are based on both quantitative and qualitative research tools, are conducted on a variety of topics of the Israeli court system, related to the legal system. For example, studies examining the effects of changes and reforms in legislation on the work of judges and the court system in general, as well as the effects of different projects promoted and initiated by the court administration to improve its efficiency and contribute to its advancement. Some of our studies are conducted in collaboration with academics and other justice agencies, such as the Israeli Prison Service, the Ministry of Justice, State Attorney's Office, Public Defender's Office, etc. Over the last few years, we've conducted a very comprehensive and extensive study on judicial workload in Israel. This study was designed to update, expand, and refine the case weight study that was conducted by the Research Division in 2013. The case weight study was a pioneering and groundbreaking study, and for the first time, the Israeli court system was able to balance the judicial workload in different instances in courts based not only on the volume of the cases. The decision to renew and improve the previous case weight index arose due to several factors, among them the time that passed since the previous index, the addition of new case types that were not included in the previous index, requests from judges to re-examine the findings, amendments to legislation and case law, and of course the methodological innovations that took place in the case weight research literature since the previous index. The study of judicial workload is the first study conducted in Israel that measured in real time how long it takes judges and registrars to handle their cases. The study was conducted in 2 stages. The first stage was initiated as a pilot study that examined the feasibility of conducting a time study. Attorney Shani Benkin, a former researcher in our department, led the pilot in 2018 in the regional labor courts. In light of the pilot's success, the second and main part of the study was carried out in 2020 in all district, magistrate, family, traffic, and juvenile courts, led by attorney Dalia Ehrenthal, our head researcher, and myself. In this study, the data was collected over 5 consecutive weeks, during which the judges filled out daily time logs, reporting the exact time spent on the judicial tasks they performed throughout the day, including preparing for hearings, the hearings themselves, writing decisions and final judgments, and time spent on tasks that are not directly related to specific cases, such as training programs, weekly staff meetings, updating themselves on recent rulings, etc. The time measured for the different judicial tasks were reported by 676 judges and registrars, who constitute about 87% of all the judges in these instances. At the same time, 763 court typists filled out time logs in which they documented the time each hearing took. Throughout these 5 weeks, we collected a total of almost 16,000 judicial time logs and collected data on about 50,000 different hearings. And from this data, we were able to calculate the judicial time that it needed to handle 167 different case types and subject matters, which were about 99% of the cases closed in the various courts in 2019. But in addition to the judicial workload index, we were able to describe the average judicial workday, including all judicial activities, not only those related to the specific cases, and the average amount of hours the judges and registrars work daily, weekly, and annually. Thus, the results of our judicial research allowed us not only to recommend how to balance the workload between the courts and the instances, but also how to calculate the amount of judges needed to deal with the growing number of cases the judiciary faces on a daily basis. However, we weren't only interested in calculating the time it takes the judges to perform their judicial tasks, but for the first time in this study, we addressed additional issues that are currently of great concern in the court system and scholars. Both the extensive mental burden imposed on judges, which is expressed by pressure and burnout, and the emotional stress or burden imposed on judges when dealing with certain types of cases. These issues haven't been examined so far, as they are hard to quantify and measure, and still are. Our initial work and findings emphasize the need to address these troubling issues and provide support for those judges confronting them. And indeed, these issues are part of the court administration's agenda. They've built various workshops, training programs to deal with the emotional and mental burden and offer professional and psychological guidance and support to the judges. The findings regarding the significant workload imposed on Israeli judges, which has been widely discussed, particularly in comparison to the judicial workload of justice systems worldwide, can be attributed to for a few things. First, the extremely high number of filed cases in Israel. Approximately 850,000 cases are filed every year, which is more than twice the European average in both first instance civil and criminal cases, based on the data from the CEPEJ's comparative report. We have lack of judicial personnel. We have about a third of the European average, and a large number of lawyers, which is actually the highest amount among the European countries. As found by our study, this workload is expressed by longer working hours compared to other judicial systems, including working on vacation days and sick days, lack of work-life balance, and emotional stress resulting from the judicial workload in general and among those handling these specific cases in particular. The combination of all these factors show the great importance of the judicial workload study and other studies conducted by our division, which through its research seek to help find solutions, facilitate the judges, and help ease their workload. In addition to heading the Israeli Courts Research Division, I serve as Israel's national representative at CEPEJ. Since the acceptance of Israel into the Commission as an observer state, an important move promoted by my predecessor, Professor Karen Weinsheld-Maugel, we have had the privilege of participating in meetings and conferences where we learn about the activities of other countries to promote justice and that of the CEPEJ. In addition, we're the first observer country to participate in the comparative report published by the CEPEJ every 2 years. The comparative data received allow us to examine ourselves in comparison to other European countries on various issues as I've just presented. Through the CEPEJ reports, we can also examine ourselves on various efficiency indicators or performance indicators, such as disposition time, which is a theoretical time necessary for a pending case to be resolved, taking into consideration the current pace of work. In Israel, the disposition time is 314 days in comparison to the European average of 201. And clearance rates. For example, for first instance civil cases, the clearance rate in Israel is 100.7% in comparison to the European average of 99%. Another source of comparative information is the EU scoreboard. The data presented in the scoreboard includes data collected by the CEPEJ, but not only. This report compares EU countries in various indicators as have been presented by Professor Paul Nemitz. In the context of the theme of this conference, with this report, we can also compare ourselves on issues of judicial independence. The EU scoreboard report chose to examine the question of judicial independence in two main aspects: the perception of judicial independence among the public and structural independence. Though the comparative reports allow us to conduct comparisons between Israel and other European countries, these comparisons must be made with caution. This is due to differences between the legal systems, methods, and traditions of the different countries. For example, when looking at efficiency indicators of civil and criminal cases, it's important to understand what types of cases are included in their data and if it's comparable to others or to ours. But that being said, our participation as an observer state in CEPEJ allows us to collect and obtain important comparative data and to be aware of cutting-edge projects led by legal systems in other European countries. In addition to our focus on judicial workload, in the past year, the research division has conducted several interesting and significant studies that examine the integration of technology into the work of the court system in various ways. This is part of a global trend of recent years, as evident by the different CEPEJ work groups on AI and cyber justice, and even more so due to the changes brought about by the COVID pandemic. The first study is an accompanying study to the live broadcast pilot of Supreme Court hearings that began in 2021. The study examines whether the traditional concerns raised in the context of inserting cameras into the courts do exist in Israel, both in terms of the conduct of the parties in the hearings and in terms of the media coverage. The study was extended an additional year and will be completed in the end of 2022. In addition, the Supreme Court President, Justice Esther Chayut, just decided on another pilot program of live broadcasts of judicial decisions in both district and magistrate courts. The second study is an accompanying study for a project related to documenting and reporting hearings instead of using court typists. An expansion of the pilot that began in the Haifa district in 2018 has just begun in 2 other districts, and we're following the pilot and conducting a study on its success. The third study, which was recently completed, examined the use of video conferencing in detention proceedings. The acute need for this study emerged with the emergency regulations for COVID, which, among other things, allowed detainees to participate in detention hearings through VC from the detention centers and prisons. The use of VC has been discussed for years, and a study was even conducted in Israel in 2010. However, it was COVID that created an increased and immediate need for VC in Israel, but not only. The study was conducted in collaboration with the Ministry of Homeland Security and the Israeli Prison Service, thus allowing us to present a complete and comprehensive picture of the impact of the use of VC in detention hearings on all the participants: judges, detainees, prosecutors, and defense attorneys. In the comparative literature review, we did not find such a comprehensive study that examined by questionnaires, observations, and quantitative analysis of case data the possible effects of VC on the various actors. I don't have time to go into all the findings, but I would like to present some of the main ones. The study found that the satisfaction of all the participants in the study of the VC hearings, including judges and especially the detainees, were higher compared to frontal hearings. Most of the detainees preferred to conduct their hearings through VC, and more detainees felt that they could express themselves during the VC hearings than in the frontal hearings. The use of VC, we also found, did not significantly affect the ability of the detainees to understand the judicial decision. It did not affect their evaluation of the procedural justice of the process. It didn't affect the length of the hearings or the decisions of the judges. In fact, the judges believe that the VC should be continued to be used in the future while stating certain exceptions. We are now starting another study in collaboration with the Ministry of Justice and the Ministry of Homeland Security to examine VC now when we're not under the emergency regulations. So as you can see, the division's work and its various studies in general and on the study of judicial workload in particular enables our administrators to make decisions based on valid data and information as they work to solve the problems of our court systems face and to advance the judicial system in accordance with the changing needs, as seen during the COVID pandemic and according with the prevailing worldwide trends. Thank you very much.
Thank you. Thank you, Gali. This was fascinating and very important research being done.